very interesting presentation. I just had a brief question. If you'd like to say a bit more about this distinction between rights and principles in the Charter. I think you briefly mentioned it in the presentation. I'm just interested in your views. Does it work? Are you a bit more skeptical about it? So I just wanted to invite you to say a bit more about that.
There was a question at the back?
Yeah, just following on from Josh's point and the discussion you had there. What we haven't quite mentioned is the distinction between process and substance. And I know there is a lot of literature about process and linked to proportionality in the context of the European Court of Human Rights. But I thought, you mentioned the German case, and that it seems to me to be a very procedural case about the rationality of decision making, about the quality of calculations, which seems to me to be a very procedural judgment. So do you think the minimum core could look something like that, something of a more procedurally based thing? Do you think it's obviously a troublesome distinction because process very easily collapses into substance. What would you thoughts on that?
Thank you. Can I ask a question at the end? Following up from a couple of people. I mean, using ECHR as a drive to protect social rights, do you think that it does more good than bad? I mean, maybe these vague notions of social rights, they undermine the effectiveness of protection of something that is a bit, not much, but a bit clearer than social rights.
Okay, lots of great questions. I think I could write a paper in response to every single one of those. So I'm just going to fire noise at you and you can decide how coherent it is. Mike, the wrong institutions. Yes. There's a very interesting book by Cécile Fabre in around 2000 where she says that social rights adjudication is important, but it should be done by equality human rights commissions, not by courts. Now, human rights equality commission is never going to have that status, because no one's going. It's going to be seen as an enablement ex principle. Here we have all these human rights activists sitting and deciding what social economic rights will be. It's never going to have status. But yes, ideally, for reasons linked to the economic arguments and everything else, this sort of decision-making probably should be channeled through different institutions. And you're only going to get, you're not going to get, courts are not particularly well equipped in this. And I would make this point about a lot of different human rights issues as well, not just this. But, courts aren't very well equipped. Of course, there's always the issue about courts have a certain established status. Any new institution isn't necessarily going to have that status. You see the weakness of parliamentary committees sometimes, as you will know, how easy sometimes they can be sidelined, and they have a big formal status in the system. So there's a big issue there about how to construct institutions that are in any way effective, but that's a different story. But yes, in principle, I agree with you. The only issue is, and this gets back to the question about Article 3, for instance, the question, cases are going to come to the courts anyway. Okay? Academics, are a great tendency to sort of say, oh, this isn't the right sort of issue for courts to be dealing with. If my friend who shall go nameless gets instructed, she's going to be in the JR list on Tuesday seeking an emergency order for an Article 3 housing. An emergency order requiring court landed local authority to provide adequate housing or not comply with Article 3. You could moan and groan that she shouldn't be taking these cases, that she's undermining the system, but she's going to be there in the JR list on Tuesday morning. Lawyers are always going to push the boundaries of the law. That's their job, especially if they're trying to campaign for clients who are often in appalling situations. So I think it's inevitable that existing legal instruments will be deployed for socioeconomic rights purposes. Does this affect their credibility? Possibly, depending on what the results of the process would be. And certainly if the courts were to suddenly go, yes, we're having full-on socioeconomic rights review, all coming in through Article 3 ECHR, yes, that would be a credibility issue, whether Strasbourg or in London. Having said that, there are probably some arguments you could make about how human rights will lack credibility if it doesn't have some sort of social dimension. That's maybe a discussion for another day. There's lots of potential in Article 3 and Article 8. And already there's a lot of interesting case law bubbling up, is all I would say. And we'd have more interesting case law if local authorities didn't realise how much potential there was there and kept on and didn't keep on setting. Okay, but there's a lot going on which is flying the radar. Right? That's all I can say to that. Two final points. The rights principle distinction. You're not allowed in certain human rights circles to be rude about human rights instruments. I love being really rude about the EU Charter of Fundamental Rights. You know, I don't sign letters saying it's disgraceful to be kicked out of the UK legal system. People give out to me for that. I really think it's a hugely problematic document. One hugely problematic document is that you need to go to its supplemental text to discover that what appear to be rights are in fact rights and principles, and even the supplemental text doesn't explain which are rights and which are principles. I think this is extraordinary. I think it's a fiasco, to be honest. You know, the notion you need to go to the Presidium explanation of what the Charter is to discover a legal distinction, which then isn't even clear. I mean, I think it's a farce, to be honest. So, and I think it's a very messy distinction, because you have a situation now where the Court of Justice, in interpreting the Charter, tends to say, well, this is a principle, this is a right. So non-discrimination is a right, duty worker consultation is a principle. It tends to state that as if it's obvious. Not necessarily obvious. And the whole thing is a bit of a mess, to be honest. So it's one reason why I'm a bit annoyed about the Charter. What they're doing is they're applying an approach in Germany and elsewhere where there is distinction between rights and principles, but the distinction, as you probably know, is a lot more developed than in other countries' legal systems. And there's something to be said for the rights principle distinction. My objection is that the Charter smuggles it in through the back door and then doesn't comply with it. So it's not so much the rights principles distinction I'm objecting to. I think that distinction can be valuable. It's just as implemented in the Charter, I think it's usually problematic. Finally, process substance. I'm writing a paper on this, so I'll shut up and I won't give you my full answer. I think it's fascinating. The Hartz 4 judgment was a process decision, but at its heart, you have the Constitutional Court taking a very clear decision as to the substance of the rights concerned. They're saying that they have this line about welfare support must be enough to enable participation in the life of the society, and then they develop a little test, a rather interesting substantive test as to what that entails. And that at its kernel, there's a definition of the substance of the entitlement there. And I think that process review always entails some element of substantive review. You will see some people publish articles saying you can do socioeconomic rights review purely process, with the courts never having a stance on substance. I think that's not how the world works, and I don't think it should be how the world works. The court can't review government action without having some sense of what it considers they should be doing, which entails some sort of substance. Yeah. So you could primarily have a process-driven review, where it's always going to require some engagement with substance. I don't think you can escape that.
Thank you very much. I think that was a fantastic discussion, and I would like to thank Colm for his time and for his eagerness to share his expertise. A couple of more points before I would like to repeat that on the 19th of November, Daniel Ritziker is coming from the European Court of Human Rights, talk about international law. What they know about international law and the European Court of Human Rights. There was a question, it wasn't a statement. And then the members of the unit, I think Ben will be contacting in relation to current affairs forum that we will have in the next couple of weeks. And finally, we are not ending our discussion of social rights in this unit. In semester 2, Professor Aoife Nolan is going to join us. She is a current member of the committee on which Colm was sitting for 10 years. On that note, thank you very much for coming, and I wish you a very, very good afternoon. Cheers. I should switch off the recording device.